Friends, welcome to Investment Immigration Conversations. As you see, I'm with friends. I'm your host, Carolyn Lee, principal and founder of Carolyn Lee Pllc, a U.S. immigration law firm dedicated to helping clients build their futures with investment immigration. And look at this. I've got Suzanne Lazicki. I've got David Morris. Who can ask for anything more? And really, you two need no introduction. Everyone in EB5 space knows you. You have been long-term players in this space. And I don't use the word player in the sense of, doing the sort of moving and shaking, but you're known, you're prominent, you're respected. And I'm just, one of the privileges of my life is knowing people like you and calling you friends. So, and you.
Our privilege as well, Carolyn.
Thank you.
Yes, I will say the same thing. Carolyn, you and I have been friends and colleagues on the AILA committee for 10 years or longer, and I always highly value your input and comments and your wisdom. So couldn't do it without you. And Suzanne, you're always a wealth of information. I read your blog all the time, and I think, wow, I didn't know that. So keep up the great work on that, please.
Well, let me warn you, here's my preparation of questions for you guys. Get to.
Well, Suzanne, we've only got an hour and we want Q&A at the end. So take it easy on it.
Yeah, I really look forward to hearing your insights.
Oh my goodness. Well, whoa. So today is about looking back at this intense year in EB5 in 2021. Wow, one for the books. I mean, it's got everything. We have had incredible agency delays. We've had a change in administration. We have processing times that are really unbelievable. It's really hard to believe that we have reported 44 to 77 months processing times for 526s, up to 63 months on 829s. The agency is getting sued as a result of these delays and other things. And hey, speaking of litigation, litigation to undo the modernization regulations that came in effect in 2019, successful. Now we're back to the old regulations. But for how long? Because the government appealed that decision. We've got legislation that's been hanging over us all since 2015. What's it going to look like? We've had several iterations of it, and now we have no legislation. We're in a lapse, and we've been in a lapse since June. So this is an unprecedentedly complex time in EB5. And I just thought so we're going to be looking back. The purpose of this webcast today is to kind of for us three to talk about what has happened, what's our perspective on it, what do we think about it as we chew these events over, and just do a little bit toward the end of looking ahead. There's a lot of conversation about, well, what's next, and understandably, because we're all so anxious about it. But I do want to spend this time to kind of help us all digest this intense year. I thought it would be fun to kind of start by asking you, with all of these things in play and kind of knotted together, what's a metaphor that comes to you, or a picture? I mean, is it like, is it like a twine in a knot? Does it feel like we're Sisyphus pushing up the boulder up again? I mean, what picture comes to mind, or a phrase?
Well, okay, so for me, I'm picturing a long, dark tunnel with a tiny little speck of light at the end. And I think we have a little bit more ways to go, but there is a light, and I'd like to think that we can reach it.
Suzanne.
And let's just hope it's not wait, and I say, and I also hope that it's not a train coming towards us. Yeah.
I was about to say, what comes to mind for me is the moment in March 2020 when a global pandemic had been declared and emergency declarations were under place. And I was standing in my living room and there was an earthquake and my house started to shake. And I thought, what more can happen? An asteroid? And that's what it felt like in EB5 this year. And for the past several years, actually, it's just one thing after another. Any one of them could be a death blow, and we just keep getting another and another and another.
My goodness, wow. I'm just taking a second to take all of that in. So
I'm looking forward to hearing more about that light at the end of the tunnel.
Yeah, wait, Suzanne. So mine has a nod of optimism, and I'm not sure yours, other than saying you survived locust, earthquake, and a pandemic. I guess that's optimistic. Like, what else can take you down?
Well, I think a really important thing though is what did we learn from this year? Because at least we must have that come out of this experience. Hopefully we learned something that we can apply going forward. And
yes,
this kind of reflection is very helpful from that perspective.
And Suzanne is here. She survived the locusts and the plague and the earthquake and the flood. And so, yes, I think that in itself is reason for optimism. Well, yeah, so let's get to that. So what did we learn? There are lots of different ways for us to kind of cut and dice this and try to, chew it in bite-sized pieces. I kind of thought about it like, should we just sort of try to unpack what's happened sequentially pre-June 2021, and then we can talk about our experiences with June and what's happening after, what's been happening after. Suzanne, I kind of feel, do you want to kick us off with some questions since you have a sheaf of?
Yeah, but one question I have for you, Carolyn, is what did you think was going to happen?
Oh gosh.
And especially prior to June, back to the beginning of the year and what we were hoping for.
Well, okay, so to be perfectly candid, toward the end of 2020, the efforts were starting up again, and I must say, the legislative efforts were starting up again. And at first, I think I felt like, oh boy, here we go again. And I probably had some skepticism about it all, and just from the rounds and rounds and rounds of it, going back to 2015, really going back to 2012 in my own experience.
Right. Yeah.
But as the perspective is, once you're in it and you're kind of in this vortex and you're kind of working toward a goal, you kind of get really super focused on it. And so I mean, for myself personally, I wasn't even thinking like what's going to happen. I was just focused on the effort.
And by the effort, you're talking about working on the Grassley-Leahy bill that was being put together in late 2020?
Yes. Yeah, very much so. So yeah, I don't think I took a moment to think about, is this going to happen? I think I assumed it would if I had to answer the question point blank.
Yeah, I'd say pre-June 2021. I mean, I think we all were feeling optimistic, right? Here we go again, like the prior 16 times or 19 times. I don't know how many times our pilot program has been extended, but it's probably somewhere in that range. So we've seen this before, nothing new here. The new thing was we were disconnected from the other pilot programs, E-Verify, Religious, Conrad. So that was a little different, and that definitely made me think, we got to be serious about this, because we always had cover being part of the other programs, and we always knew they would get extended, and if we stay with them, we will too. But being broken free and standing alone, we definitely were more vulnerable. But that being said, and there are certainly critics of the program, but I think we all felt that there were enough champions of the program that as legislative efforts, as Carolyn mentioned, started back up again, and there was one or more bills that we could actually see and touch and talk to staffers and, work on. And our committee, we provided kind of reports back on different sections and why it worked and why it did what they thought it was going to do and why it was going to do something different that they thought it should be changed. So we had some work to do. And so I think pre-June 2021, I'm like, all right, yeah, it's going to be bumpy. Maybe we'll have a short little lapse, but we're going to get this done. And that was how I felt up until the lapse.
Yeah.
When I was looking back at public statements that had been made by various people leading up to June and what people said what they thought the lie of the land was and what they were expecting to happen. Looking at AIUSA, for example, in Aaron Grau's State of the EB5 Industry that he published in January 2021, what he said about the state of the industry is that Grassley-Leahy bill is the best and only option for reauthorization. We don't have the luxury of time. We're going to have to support this in order to get a reauthorization. Otherwise, we're just going to go and do fruitless negotiations over a grand design that we don't have the time and capital to get right now. So that was the IAUSA perspective. And then Laura Reeve of EB5 IC, speaking to EB5 Investors Magazine in March, was saying that some people feel like they have to support Grassley-Leahy, but it would kill the industry if it came through. And the option that EB5 IC seemed to suggest in a press release they put out in May was that there could be a short-term reauthorization, or we could make even Grassley-Leahy very short-term, but get something short-term so we have more time to get a holistic thing going. And so those seem like they were the expectations. Either we have to get Grassley-Leahy, or maybe we can do something, put it off to get more time. And I don't know your perspective on that. What were you thinking was going to happen? Were you thinking we are going to get Grassley-Leahy on June? Were you thinking we're going to get a short-term extension in June? And I don't know how you see the lie of the land now that we've been through all that, as far as what are the options. Sorry, that's a lot all at once.
Yeah, I mean, those are the questions on our minds. Hearing you and just thinking about Aaron's statement again, it strikes me that he was right, because there was nothing else at the time, and there wasn't anything else on June 29th. No other vehicle that would extend the EB5 Regional Center program. And so I think that those words have turned out to be prescient, because there was nothing. And as a result, when the Grassley-Leahy bill did not go forward, we have had nothing for the last 6 months. So, I mean, in terms of what Laura's comment was that you summarized, I think that that the holistic reform to EB5 is certainly not unwelcome, especially now. I think we almost need it. At this point, it feels like that is the way to go. That is the way forward, because the litigation on the regulations have thrown up so much uncertainty into the air that the only way, and maybe not the only way, but the only way it seems to me at this moment to clear that is with definitive legislation. I guess the only other way would be to have disposition on the bearing litigation at the circuit court level. And that could happen. There is an accelerated, my understanding from reading the Ninth Circuit procedures is that there's this, normal track, and it's difficult to predict how long a case will take to conclusion on that normal track. It would take a while. And then there's the shorter track, and if it's on the shorter track and it goes before a panel, we could have disposition on that much sooner, within shorter than a year, in months. once there's a briefing schedule. So the lay of the land,
it seems to me that there are 2 points of what Laura was saying. One is that we need holistic reform. The other is that we can get holistic reform. And you have reiterated that, yes, we need it. Have we modified our ideas at all this year on if we can get it and when?
If we can get it and when. So my feeling on this is that finally, it feels like the fate of the EB5 legislation turns on larger forces. These larger forces are more at play than the sort of internal debate about what the future of EB5 Regional Center program should look like. What should the TEA be? What the differential ought to be? You know, I think we were kind of very, very preoccupied with those interior questions to this point. And on those questions, I think truly we are closer than ever. So that's very positive. But now that we are, and now that we kind of are working off of literally singing off the same hymnal, working off the same text, now it feels like we have these larger forces of, you know, how do you get a bill through Congress?
Yeah. So Carolyn, that's what I was going to say. I guess, you know, Congress is kind of dysfunctional right now, right? More so than ever. And immigration has always been kind of a hot stone issue, and it is now more than ever. And, you know, if we do with a modified Leahy-Grassley or any EB5 reauthorization, I suspect it will also be a 100+ page bill. And how do you get that passed right now in Congress? It's just a hard thing to get done. And so, you know, that's the difficult thing. People keep thinking of like, well, what can we attach that bill to that is going to must pass legislation? And I think the fact that it's an immigration bill makes it hard. The fact that it's 100 pages, whatever version it's going to come out to be, is going to be hard. And it just makes this task even more difficult. And I think it probably has really risen up more to the powers to be, the leadership in the House and the Senate. And I think certain stakeholders in the EB5 industry that are driving that more than, you know, us common folk. And so I think we're all a bit of observers to this all more than we are active participants in getting it passed.
Yeah.
And so that's the frustrating part.
You know, that all said, and I completely agree, of course, with everything Morris said, is, you know, I do think that I don't mean to suggest that we should kind of, you know, that we're powerless in the face of these larger forces. I absolutely think it's a feeling, you know, it's not, I feel that it is critical that there be that momentum and push at this moment for us to get over that hurdle. And whatever that must pass vehicle is, we've got to hook ourselves onto that and cannot assume that it will just happen. It won't. It will not just happen because we're in a lapse. We're on nothing. So any extension is not going to include us. So there's got to be this affirmative push to get us hooked onto something. I think we all need to keep our eyes on that.
The story that I have gathered over the course of this year, and also from hearing reports from AIIA, the investor organization that just went to Washington and talked to a bunch of staffers, the impression that I got is actually sort of a simple story in 2022. And I'd like to hear your ideas on it and whether that's the case, that next year, basically the option is to get attached to appropriations, that Senator Leahy is the gatekeeper for that option. And therefore reauthorization is going to be what Senator Leahy wants if it happens. Is it that simple or not that simple?
Well, it could be that simple, but is that simple? Is that simple? I mean,
well, is it the fact that practically our option is to have the reauthorization bill that Leahy wants or nothing?
I mean, that Leahy wants.
That Leahy is willing to
we don't even know what that is, right? We don't know what that is.
Well,
So,
Well, I think we have a good guess what that
Yeah.
is, though, considering that we know what Leahy has said about EB5 for the past 30 years. We know what's been in his legislation. We know what he reacted to in the industry consensus bill. So there might be a few mysteries, but it's not very mysterious,
Yeah,
right?
yeah.
Well, how can
Yeah.
we untwine, right, what Leahy wants versus what Grassley wants? Right?
I don't think that.
So how do we know that?
Oh, I see.
So I mean, I don't think we know. And
Yeah,
so
I don't think that's really, we do know. I mean, I mean, if, do we want to parse?
At least if we don't know, we can find out, right? We go talk to their staffers.
Yeah. So, I mean, the way that I understand your question is Senator Leahy important? And from everything that I know and can gather, yes, he is. He is important. To the, how important, I mean, if he absolutely objects, will this not, that I can't speak to, but he is important. And I think for this process, for us to have a law, to have the highest chance of a law and reauthorization, we need Senator Leahy. Yeah, and to me—
Would you say that's something that we've learned from this year? Because for those of us on the outside, it's a little bit hard to tell. Like when people said, oh, we have a chance in September, we maybe have a chance in October, we maybe have a chance in December. It was hard for us to tell, was there actually a chance and we lost it because it was blocked by Senator Leahy, Senator Grassley, or was it not really a chance just because of the legislative process and how you can't practically attach very much to a CR? I don't know what your perspective on that is.
Oh, I don't know. I mean, I don't have a perspective on that.
And in this case, not trying to put the blame on anyone, just thinking is where is the lesson that we can learn? Is the lesson that, okay, Senator Leahy does have a gatekeeper role, therefore we need to really include his opinion in what we suggest for February?
Look, I think there's no question that Senator Leahy has to be involved, but let's remember that Leahy Grassley would have passed, but for Senator Graham objecting, on a vote. So, it's not there. Leahy Grassley have shown a willingness to move this forward, right? And we would have reauth right now, but for Lindsey Graham. So, I think Leahy's senior leadership. He has involved with EB5 for a long time, for good and for bad. And I think he wants to clean it up, and I suspect wants to extend it. But I think it's not unconditional. And I think we need to figure out, how we can reach some accommodation between kind of maybe what the industry has and what Senator Leahy wants.
Yeah.
Simple as that.
Senator, yeah.
So, so I guess continuing on with our timeline here. So we talked pre-June 2020, and then we have, the post-mortem. So I think, the reality hits and it sunsets. And I think we all thought, oh, we've never really had any significant lapse. It's been a week or a couple weeks or, nothing long. This lapse will kick into gear legislative action and this will get done, and obviously I and others who thought that were wrong. And I think we're still, I guess, stunned and frustrated by this not having been extended thus far, especially given the impact that it has on the number of, pending investors. AILA issued a report to sent a letter to senior leadership in House and the Senate talking about, in part, supporting the idea for grandfathering, of saying, you will be stranding you know, 100,000 or more. I don't know what number. Karen, do you remember what the number was? It was some gigantic number of folks who have approved 526s, and here's all the family members, and they won't get their green card unless this thing gets extended. Like, so I think that folks who got that message, it resonated with them. I don't think a lot of members of Congress appreciated that if you filed, that doesn't mean you're going to get your visa. It's not stopping just new cases, but it's anyone short of having gotten CPLR status. So I think that was helpful. But I guess the word stunned is, you know, stunned and frustrated is how I would describe, you know, the postmortem so far.
That's very interesting. And I wonder, what was it that caused you to expect that there would be action soon? And do you have a diagnosis on why we're here in December and nothing has happened? Well,
why would I expect it? Yeah, I guess why I would expect it is because we've really never had this before. And as we mentioned before at the start of this, you know, 16 or 19 times this program has been extended. And so, you know, it was always kind of the last minute, there'll be a CR or something would happen that the program would continue. And I thought, why is this different? And clearly I was wrong.
So you didn't start panicking in December 2020 when it was decoupled? At that point, you were still optimistic?
Well, again, you know, when we started this, I said that was the one thing that worried me, because that was what was different than the prior 16 or 19 times. But that being said, I still thought, you know, the program would get extended, and I still think it will get extended. But the frustrating part was, you know, the rest of the legislative world has had other priorities, including infrastructure bill and everything else, and not a 100-page immigration bill. And I think it was made clear to us that the idea of having a simple short-term extension was not something that a lot of people on the Hill were interested in. They wanted reforms. And so, you know, getting a 3-month or 6-month or 1-week extension just wasn't something that they were interested in.
Would you say that the hope that had been expressed by a number of people in industry at the beginning of the year, we're going to get a short-term extension, has that been definitively put to bed? Does everyone say now, okay, we understand?
Of course, I mean, if we look at historically, it did not happen, right? We didn't have it, and we're at 6 months of lapse. So were they wrong? I think it's obvious that they were wrong, because.
Well, I mean, I don't necessarily mean in the past, but like, are there some people right now who are hoping maybe in February we could just get a 1-year extension, give us some more time to put a bill together? Is there anyone who still hopes that? Or are people more focused on it's long-term, it really is long-term reauthorization or nothing now?
Well, I think it would depend on what's on the table at the time. Now we're guessing and we're looking into the future, but I think that it would depend on what's offered. I mean, clearly, SA 31 was not acceptable to some. And so if what's on the table is not acceptable, you're going to either accept it and say, and swallow it, or say no and wait for something better. And when you say no, you're either going to have something else to offer. And if you do, I think you'll push that as the alternative. But if you don't have that, or if you think that the time is not right to put that alternative forward, then you're going to delay, right? I mean, you're going to think, if you think that having that is worse than having nothing, and I don't have a viable alternative to offer in its place, then you're going to want a delay. You're going to want time. And I think this is the other strategy, right? Is for these other things that could make the acceptable, the more acceptable alternative have an opportunity to get on a viable track. That's when things would line up. You've got influential members of Congress who can take that agenda forward. You have some background facilitators, events in place, and that's when you present it. And then, you wish it well and you push it, and, and hope that that's the path that ends up being the one that carries the day. So, I can't remember now what your question was.
I'll go back to my big question, which is whether I need to apply for a job at the IRS and just give up.
Heavens, no,
next year.
Absolutely not.
What I will base that question on is
IRS of all ages.
Yes, I'm in Ogden, Utah. The IRS is here, so that's
Okay.
my. But is there anything that's going to be different in 2022 than 2021?
Well, I'll say,
first of all, the issue and the situation in Congress is as far as who the political players are, who has power in the Senate to either block this or take this forward, what is going to be the legislative option. It appears to me that's basically the same in 2022 and 2021. Is that accurate?
Gosh, didn't I say we were not going to speculate?
Yeah.
Okay. All right. No,
Yeah.
I will just leave that question open.
Look,
As we're trying to look back, right? We did pre-June 2021, we did post-mortem of sunset program. I think we need to talk about bearing litigation because that was an important event that happened this year. So that was a big deal.
Thanks for getting us back on track.
That was a big deal. The regional centers brought a lawsuit challenging the modernization rules, right? TEAs and minimum investment amount, and they claimed that the acting secretary did not have legal authority to sign the new rules. Good for them for challenging it. Court agreed with them and with the regional center and struck down the new regs, and USCIS recognized the return of the old rules. So that kind of opened the floodgate for all the directs, and we'll talk about that next. But I think, as Carolyn kind of alluded to, it ain't over just yet. And I think there's still a couple of things that we all need to think about. So for example, Alan Mayorkas, our current DHS secretary, ratified the regulations. So he said, okay, I don't know if I agree or not that Chad Wolf didn't have authority. The court thinks he didn't, but I am a duly deputized DHS secretary, and I ratify those regulations. So, any impact like that? People filed after that date, 526s. So any impact, and as this winds through the USCIS through the appeals process that USCIS started, will the federal courts say, well, maybe there is a difference between those cases filed pre-ratification and those filed after ratification? If that's true, and we're just guessing, but if that's true, with a big rush of EB5 direct filers, you're going to have to figure out which camp you're in, and did you make a sufficient minimum investment, and is your TEA good or not? I think that's an open issue in my book. Carolyn, what do you think?
Yeah, I think that's a real risk for sure, and hopefully, investors are being advised of that. It's a very, very messy situation right now.
I can say, as a business plan writer, it can't be ambiguous where your business is going to be located and how much money is going to go in it. That's a decision you have to make early on. And once you've made it, you stick to it. So it would just be impossible if later on they said, oh, retroactively, your location doesn't qualify, or retroactively, you need to have spent more money on this and have invested more money. So
exactly.
We really need the certainty up front. And I don't know how you're
and I think that's
your direct EB5 clients right now, as far as how they should assess the risk of filing right now.
Well, I think it's as simple as you can file now, and it's cheap relatively, but there are all sorts of uncertainties that could undo the benefit of having come in at the 500,000 level. And if you're comfortable with that, then then go ahead, go forward. But if you're not comfortable with that, then you can't, then don't.
Yeah,
You
I would
as
say
lawyers-
I would say something. So Suzanne, you used the word retroactivity. So that's kind of a term of art, I would say, right? So we have the modernization rules, right? So those went in effect. And then the court said, well, those are wrong, and threw them out. People filed, but then the case got appealed. And so if the appeals court comes back and says, you know what, that judge was wrong, those regs should stand, I wouldn't say that's retroactive. I would say, you know, the law was the law as a time. It just has been interpreted incorrectly until the appeals court fixes it. I would also say that our job as lawyers, we don't make decisions for our clients. You know, we try to educate them as to risks, you know, impacts of decisions, and it's up to them to make decisions. You know, the fear really is that if an investor says, I'm going to do EB5 direct at 500,000 because that's what I can afford right now, and so I'm willing to take that risk. If CIS comes back and says, listen, the appeals court ruled in our favor, actually, and recognize that Majorca's ratification did correct things, you know, it's hard, if not impossible, to fix a defective petition after it's been filed, right? That's one of our core rules. So you couldn't say, well,
Yeah, there
all right,
are arguments. I mean, it's the idea that a case has to be, and now we're getting very, very technical. But I think that there are arguments that these investors have, and one sort of pillar of immigration adjudication is whether a case was eligible at the time of filing, and I think that principle is where this juncture of, you know, this nunc pro tunc concept of, well, you had actually a different layer of laws that were valid at the time, rather than the laws that you thought. But I think that there would still be the claim that, well, at the time I filed, these were the laws or these were the regulations that were in place. So I was eligible at the time that I filed. Yes, you court later on can come in and say, actually, there was another set of regulations that were more valid, if you will. But I mean, I think that those investors have, they're not defenseless, but the point is that it's incredibly, it's just like a swamp, you know, like it's like you're not walking on hard ground right now. And I think that's really what investors need to appreciate.
Yeah. Yeah. Okay. That was my point. Is it's not a simple slam dunk. It's $500,000 because of the Bering case. There's a lot more to it. And I just hope that lawyers talk about that. And frankly, you know, on our discussion list is the rise of direct pros and cons. You know, I don't know to what extent all of the business promoters that are out there right now promoting directs, are they really talking about that? And so benefit of, $500,000 investment, but with that risk. And then I guess the other one is that I keep hearing about is faster processing times for EB5 direct because RCs are not being adjudicated. But Suzanne, I think you have told us data that that's not true either.
Yeah, well, if you think about the equation for processing time, there's a numerator and denominator, and it's the inventory and at what volume are they processing the inventory. And people are thinking, oh, the inventory is down, therefore the processing time is down. But what's happened is that USCIS has concurrently reduced their volume of processing to the point where it's, even though the inventory is probably down about 90%, the USCIS processing volume has gone down over 95%. So if that trend continues, it's actually going to get even worse than it was before. And so we definitely need to be focused on what's happening at IPO at the same time as we're dealing with the issues in Congress, because these are both very important to the viability of the program going
Absolutely.
forward.
And they're somewhat independent as well. You know, in terms of USCIS management and their volume management, the delays, that really is a separate thing from EB5 legislation. It's kind of a USCIS system-wide issue. So
One thing I was going to ask you, do you guys know if IPO has leadership yet? Because I know the IPO chief, Sarah Kendall, left at the end of 2020, and I haven't heard of any.
No, as far as we know, still active director. Mhm.
Yeah, there's an active chief of IPO, Todd Young. And so it's not entirely leaderless, but we've had no stakeholder meetings, right?
Right.
We've had no communications from IPO, from the leader as such. So yeah, I'm not really sure.
And I'm kind of disturbed that the one thing that happened in all of 2021 is they said, oh, we're going to give you 2-year extensions to your I-829s. And now people who filed in 2018 are getting these notices saying, your notice is now valid for 2 years from when you filed, which is completely meaningless. It's hard to imagine what kind of thinking that came out of.
It's kind of like you feel like there was a good motive behind it, you know, like, oh, we're going to get these 24-month receipts out. But the implementation, whoa, you know, it's sort of, there needs to be some.
Yeah, well, last time I checked, 2021 minus 2018 is longer than 24 months.
Yeah. By the way, the fix, and Morris can speak to this. This is, I think, his wonderful idea. The fix really is on these 829 receipts for them to be DS, or duration of status. Because
Right.
that's what they are, in fact, they're conditional permanent residents. And so this is evidence of their status. And given that to be the case, and the agency would know when they're not in status, if they're, you know, if they've been removed. That's really the fix.
Yeah.
David Morris for IPO chief, please.
Yeah, we at AILA have been complaining about this for a long time. The burden on EB5 investors and family members at the end of their valid status is printed on the receipt notice, required that they make an InfoPass appointment and go into the local office and get a stamp, which how disruptive that is, let alone if you could even get a time. And then do that every, you know, every 2 years or something like that is really bad. So we at AILA had kind of continued to raise this up and saying what a poor use of resources that the field offices have to deal with all these folks. And we even suggested some ideas. So durational status, like F1 students, seemed like a really common sense one. Another one, what we thought was that the IPO should mail out new receipt notices, I-10 receipt notices, you know, every year that extends it for 1 year. Like, why can't they just mail out new notices or make them valid for 2 years, right? The notice of itself is evidence of continued lawful status. That's their record. But instead of doing that, they're making people go into local district offices to get stamps. It's just a waste of time.
We're issuing so many of these 829 24-month receipts, like blanket, and they're not valid. So very wasteful. Yeah.
So back, Suzanne, actually, one thing that I wanted to talk about back with processing times and directs is there's this, I know promoters are saying, okay, because they're not processing regional center 526s, your 526 direct will be faster. And I've seen no empirical evidence that say that's true. And I think people are joining up and subscribing to these direct investments because of the $500,000, but also because of this expectation of faster processing time. So have you seen anything that says that the service has a special process line for directs versus indirects and versus regional center, and that they're going to do them quickly and are doing them quickly?
Well, to do them quickly, they have to be doing work at all. And that they are not doing work at all right now from what I've seen. There were 11 I-526 approved in the entire month of November, for example. I mean, that's almost nothing. So let's say direct inventory is only 1,000 cases. If you're dividing 1,000 cases by 11 cases processed per month, that's going to take a while. If they were still doing over 300 a month, as they were doing recently, then that's a much better equation.
Well, but I'm just thinking as you were speaking, So, but maybe these would have to be direct cases. And there weren't 1,000 direct cases filed a year. You know, it wasn't 10%. So, I mean, and I don't know if numbers exist on the actual number of direct cases filed year to year. I'm sure the visa
They don't
office
report those
would,
separately. Yeah.
not the service, the visa office, I would. So I'm just wondering whether the 11 cases are the only ones that they could push out, you know?
Well, that's a very interesting thing. What I've seen is that for the past few months, they've been processing cases up to November 20th, 2019, which is when the regulations happened. They've sent out a lot of RFEs on those. And the trend since June has just been each month, they're mainly processing those, but processing fewer and fewer and fewer each month. So it looks like they really are getting, at least on sending out RFEs, must be getting down to the end of the number of cases up to November 20th they could be assigning, but then they're not assigning things after that. And I know that they've got cases to assign because at least whatever was filed since July this year must be direct. That's the only thing that could have been filed. And there have been almost 100 filed since then, and those aren't getting touched. So I just don't know what's happening behind the scenes.
Yeah,
It doesn't look like a very functional system. And so I would really love IPO to get real leadership and to focus on, to see them putting value on processing, because really it's an integrity issue. Nobody benefits from cases sitting there and not getting looked at. The sooner USCIS reviews the cases, the better the EB5 integrity will be. And it's almost as if they're intentionally saying, okay, we've got a target to have a 3-year processing time. How are we going to keep the processing time 3 years when we have so few cases? I guess we need to really lower our productivity and send our I-5 to 6 adjudicators somewhere else so we can make the EB5 processing time long enough. I mean, that's almost the only way to explain what they're doing. And that shouldn't be.
Could not agree more. Could not agree more. You know, I think one of the issues that I thought we had under the prior leadership was we did not have sufficient transparency. What was happening under the hood in the office in terms of the operations? How many adjudicators were there? What explains these delays? And there were sort of general responses like, oh, you know, we've really amped up our fraud detection unit and training. Okay, wonderful. But that doesn't explain why there were, 43 cases filed in a quarter, and the output is whatever it was, not what it had been in prior quarters. So I hope the same thing. That's one of my key hopes for 2022, is that we'll get leadership at the IPO, and we'll have dialogue. We'll have the opportunity to have dialogue with the IPO, and that we'll get real information on what's going on.
Well, so that's like perfect. So what would we like to see in 2022 as we look forward? This is my Christmas wish list, right? So, I'll start with long-term reauthorization with grandfathering so that we can put that issue to rest. I think it needs to have that. IPO announces a permanent director, not an acting one. IPO puts everyone back to work and clears out the backlogs and sets reasonable processing goals of, 12 months, let's say. I would love to see in my Christmas wish here, recapture of lost EB5 visas and consulates get moving on their visa interviews. How about we do that? And absolutely agree, Carolyn. IPO commits to meaningful engagements with us as we talk about new regs for the new legislation, update to policy manuals, collaboration and meaningful engagement. I think like that's what I would love to see from a new permanent director at IPO that says we all have big work to do and it's better if we work together to get it done. And at the same time, on those meaningful engagements, to go back and revisit some big issues like redeployment and I-551 stamps for extension of continuing status. I feel like that's my Christmas wish list.
Good one. Excellent. Suzanne, what's on yours, real quick?
Well, I'm going to be contrarian and say that I hope that people give up wish lists and just really focus on pragmatism and through what is practically possible and putting their energy into that. I feel like our recent history has been undone somewhat by people just focusing on what do I ideally want and not on what's possible. And then another thing that I guess is my prediction 2022 as well as my wish for 2022 is that there's going to be a lot more transparency and a more even playing field in information as far as what's going on. And I think some of the unfortunate aspects of 2021 just came from imbalance, I guess, in what people knew, and especially investors just feeling like they had no idea what was going on. And that is something that is already changing now and is really going to change the shape of the debate, I think, in 2022, when there are more people who have access to information, who know what's happening, and that's also going to shape possible outcomes.
That's a positive 2021 development right there. More investor involvement in this. All right, let's take some questions. There's a question, there was less than 0% chance of a short-term reauthorization in June, and all the parties definitely knew that. And those are ellipses. And what is the real point? I am having trouble,
I would be interested to hear if you agreed with that, because some of the parties definitely said that they thought there was a chance
of a clean reauth.
Yeah,
like short-term,
or even just a short-term reauth.
I don't know.
Mm-hmm.
I didn't see a vehicle that promised that. There's nothing that said we're going to give you a clean reauth for a week or 3 months or anything. Very unlikely. Is an IPO broke, hence the lack of processing volume? I don't think so.
Broke as in no money, or broke as in broke in?
As in broken. Yeah.
I mean, I think, this is my guess, I think that they reassigned a lot of their staff over to other business units, non-EB5, and they're being worked over there. And as a result, EB5 cases are sitting around. And I think with the lapse of the program, it's even easier for them to say, we don't need, we're not pencils down on all regional center adjudications other than 829s. So if you guys were all trained for lawful source of funds on 526 cases, one of you might be assigned to work the direct cases that are coming in, but other than that, you're going to go work I-140s or work whatever the issue du jour or product line du jour is at the service. I think that's what it is, and I think they need to get back to work. I think they need to be reassigned back to their unit that they were trained for, and that all of our clients spent lots and lots of money on filing fees to get that service. That's my take on it. What do you think, Carolyn?
Well, I think that there's the agency is needing needs financial resources. Now that's my understanding. I don't know if there's allocation within the product lines based on the fees that get attributable to certain filing types. If that were the case, I would think, yes, the IPO should be flush. $17,000 on 924 filings. So I don't know. I don't know if that's true or not, and how it plays into.
Do you think they're not working out of austerity?
I have no idea. Yeah. I would like to know.
And I have a little tiny bit of evidence on that. There was a adjudicator that I used to communicate with occasionally by email, and in 2018, 2019, he was complaining to me that a lot of I-526 adjudicators were feeling like they didn't have job security because of the falling I-526 filing fees, and that people were looking around for other jobs and seeing the writing on the wall for that. And he even claimed at that time that IPO was looking for other forms to process. So that's,
well, I mean, it's
sad that the way the budgeting process works, that there's no revenue recognition. It's that they can take the fees in 2015, spend the fees in 2015, still have the cases pending today without those fees. And yeah.
Well, now I know why you want to work for the IRS. Numerators, denominators, reconciliation. All right. Thank you for all the, thank you, lovely. On the low productivity topic, my theory is that IPO is pretty much only acting on cases they have been mandated to via writs of mandamus. You're not the only one who feels that way.
Yeah.
I understand that IPO has to be fully self-funded and cannot draw from the general USCIS funds appropriated by Congress. Do they have to? That I don't know. I'm sure that answer exists, but I don't know the answer to that personally.
I don't know. I don't know either.
And so,
but how could they not be? How could they not be self-funded with the filing fees? I mean, you know, their work studies that they have that says it takes 23 hours to do a 526 case or whatever it is, right? When we know the way the service works is for regional center projects, once they approve the projects, that gets put to rest, and then the examiner is just looking at lawful source of funds, lawful source and path of funds. So, you know, what are they doing with the other, you know, 90% of their hours, right?
Interestingly, I've heard that it's come out in mandamus litigation and USCIS responses that USCIS admitted that those numbers they put in the fee rule for amount of time on EB5 forms are simply made up because they don't have a way to know how many hours a form takes on average.
yeah.
And interestingly, also in the fee rule, their estimate for their volume of filings that upon which they based their budget was also made up. It wasn't based on their actual numbers for what had been their recent filing numbers. So if they have budget problems, it's very understandable why.
Suzanne, feel free to ask us your remaining burning questions or pick one or two while we wait if there are other questions. We're zipping.
I would love to end with a reason for hope in 2022. I guess we touched on.
If it's a really hard question, ask Carolyn. Don't ask me.
The reason for hope is, oh gosh, now I'm going to sound totally Pollyannish and embarrass myself.
Please, we all need that.
Well, so when I was asking you guys earlier, how do you picture what's happening right now? To me, one picture, there are a lot of pictures that emerge, but one is puzzle pieces that are kind of floating. And when they're in that state, you can't see how they're going to fit together. But I do think that it's very appropriate that we are where we are. It's not an accident, it's a culmination. And I think that when the pieces settle, what will come out of it is a better, stronger program that's more robust. And I think that this is the process we have to go through to get there.
I agree 100%. Yeah, 100%. I just wish we had gone.
Yeah.
I wish that this waiting period was compressed, that we could have taken the pieces and put them together a little sooner. But I agree with you. I think we needed to go through this.
Yeah. And, you know, in terms of those thousands and tens of thousands of family members of investors and those projects, you know, I just cannot imagine that we'll let them down. And we collectively, you know, everyone on the industry side, the bar, Congress, the executive, we can't let these investors down. That's just not an option. And so how do we get there is really the question, and when.
I'm glad to hear you say that, because in fact, in 2021, they were let down to buy more, get some better legislation. So I'm glad to hear you speaking for these groups saying in 2022, that's not going to be an option. If we get the option where it's A, take something that's suboptimal, B, delay more to get what we want. I hope people are going to look at that B and think, what does delay mean? And what is the bloodbath that's going to come out of that?
Make me queen and just watch what I can.
Yes, please, please.
I'll be loving and kind, I promise. We're at the top of the hour. So Suzanne, I mean, I think we hit all of our questions. I'm gonna just check one more time. Yeah, we did. Morris, Suzanne, you know how much I treasure you on many levels. Thank you so much for joining and for asking your questions, sharing your insights. It's really important that people hear from you, and just thank you for coming on and sharing your thoughts.
I really appreciate you being
Thank you so much
throughout this.
Thank you, thank you. Happy and merry.
Thank you for having us. And by the way, shout out to Matt Galati, who he referenced his big mandamus win. So thank you for that. And we got a lot of information and some good holdings out of that. So unfortunately, we need more litigation, because the only way the service seems to respond is by litigation. So maybe this is also going to be the year of reauthorization, but continued litigation.
All right. On that note, have a wonderful holiday season, everybody, and we'll talk to you soon.
All right. Bye-bye.
Bye.